Swayam Prabha. Digital India. Educated India.
Dear students, welcome to the class of Transfer of Property Act. Myself, Dr. Amarendra Kumar Ajit, Assistant Professor of Law, Faculty of Law, University of Delhi. I am going to discuss about basic concept of Transfer of Property Act in this lecture. And mainly I will cover the concept of first of all property, different kinds of property, and then in certain terminology which is given under the interpretive clause of Transfer of Property Act. So, first of all I will start with the concept of property. In case of concept of property, any property is a kind of right. And this question then comes that what is actually rights? Rights is a legally protected interest. This legally protected interest is protected by law making authorities, and law making authorities or recognizing authorities in modern state may be legislation, judiciary or executive. So, when your interest is going to be protected in form of right with respect to any tangible or intangible things, then it may fall under the category of property. So, the basic origin of this word property itself is from a Latin word that is proprietas. Meaning itself is that one's own. When we are saying that one's own, that means it is related to that person, and person has certain types of claim over that property. How it claim establishes, then for that purpose various types of theory has been developed in jurisprudence to claim the ownership over property. And they have defined this concept in various theories in different way, but overall is that there is a claim, whether this claim you are going to satisfy through the historical perspective or through the mental element like in psychological theory, or in case of certain function or philosophical theories on jurisprudential basis. So, generally we describe properties in different ways, but common element remain always constant, that is a kind of claim over certain goods, tangible, intangible, certain kinds of claim. So, this has been defined by various scholars in earlier time, and most of the scholars you might have read in the jurisprudence that how they have defined it. I am going to take few scholars' name and their definition from different schools of jurisprudence. So, first of all, I am going to take Anderson and Parker, who is a sociologist, and said about the property that property consists of goods and services that society gives an individual or group of individual the exclusive right to possess, use and dispose of it. So, according to his definition, this any kind of property is a kind of goods or services which the society has given a kind of right, that means acceptance of that claim, and the person will have three essential things which is the characteristic of property: to possess, to use and to dispose of it. Salmon says that the property can be categorized into two forms, that is right in rem and right in personam. So, this when we talk about the property which I am going to discuss in the Transfer of Property Act, that it has been called as it is in right in rem. That means any person will have right over that property against whole world, that no one can come and claim it and can use it. That is against the whole world, this right is there in that property. When we talk about right in personam, that means there is a difference between right and rem and personam. Any person will have claim only against that person. Mainly it is about the contractual obligations. So, what we are going to discuss in this paper, it is mainly about the right in rem. And next important point has been said by Bentham. Bentham says that property is not originated by the occupation of an ownerless thing, but it is a creation of law. It is a very, very important point here, that it is a creation of law. If there is no law, there is no recognizing authority, because in the earlier I told you that interest which is legally protected. That means this legally protected, it says that it is law has already recognized that claim. So, he believes that the property exists only when there is existence of law, and according to him the term might be understood in one of the three senses. What are those? The first is property includes all legal right of a person. That means any kind of right he has term in the sense of property, that is to say that it includes complete ownership of a man on material as well as incorporeal things. Second is that the term includes not a man's personal right, but only his proprietary rights, that is rights in rem, and term includes rights of ownership in material things such as building, etc. In more or less in the same sense, Austin says that property denotes the greatest right of enjoyment known to the law, including the servitudes. Property includes both proprietaries as well as personal right of man. Then we come to the types of property, which is very important here, because the types of property, which kinds of type of property is and what is going to be governed under this Transfer of Property Act, it is important for that. So, first we see that there is a categorization of property in public property or private property. Public property, generally we used to say the property of the government, whereas private property may be the person, natural person, this legal person, any companies and all. So, in that way it is private. Real and personal property, this is the bifurcation of property in mainly in UK, now in common law countries. So, real property, it is related to the property of land related thing, whereas personal property is that related to the person who is owning that. Then most important is corporeal, that is tangible, or and incorporeal, intangible property. Corporeal or tangible means which is visible in nature, that means which you can see, you can feel through senses, that is corporeal in nature. Incorporeal, intangible means which is not visible, which cannot be felt by senses. So, in that way it is tangible in nature. So, this movable, then we categorize this corporeal properties into movable and immovable property, and it is very nomenclature itself suggests that movable means that the any kind of goods, any kind of things which is movable in nature, which can be keep here and there. So, that is movable. Immovable means which is fixed in nature, which cannot be moved. So, mainly this movable and immovable property are the part of corporeal property, whereas in case of intangible or incorporeal, we used to say about right in re aliena and right in re propria. Then in that way we define this how we are going to use all these different types of property in Transfer of Property Act. So, basically in Transfer of Property Act, if you will go through the preamble of the act, why it was enacted, because the year is 1882. In case, and Contract Act came prior to this 1872. So, law of contract was also a kind of giving a right to the person, but with a specific person. So, right in personam it has created. Something was blank at that time, even after the Contract Act, that the transaction related to property, how it should be governed, how it should be regulated. So, there was a requirement of certain formal law on the issue, and for that purpose this Transfer of Property Act was enacted. And this, before this act, how this transfer was governed, transfer related to property, it was governed through the law of equity or common law principle. So, earlier this was the stage, but after this transfer of property, which is mostly recognized as the incorporation of principle of equity in this act, it is a kind of a codified equities law with respect to the movable and immovable transfer of property. So, the scope of this act is very limited in the sense that it talks about only the transfer of certain kinds of property with certain class of people. That means, class is limited, that whose transfer will be covered under this and who are going to come under this. So, the transfer of operation by law is not protected under this. Transfer of protection of operation of law is not validated. What is the meaning of this? That invalidated by anything contained in act. Some transfer happens automatically. Automatically means, that means through succession. Okay. Through succession, if something is happening, that is called non-testamentary form of transfer. So, if something happening through that without any registration, without any kind of transfer, then it is not covered under this act. So, scope is limited. In same way, if it is happening through the registration act, even though it is not covered in this. In case of certain personal laws, just like in the case of Muslim laws, there are rules of succession. So, certain personal laws transfer or successions are also not covered under this. So, the scope of this act itself is limited, and in that way it has been said in the preamble that there will be consolidation of law, but it is not holistic consolidation. That means, it is not exhaustive in list. All law related to transfer is not codified under this. Next point is that it discuss only with the transfer of property inter vivos. What is the meaning of inter vivos? Inter vivos means the transfer in between living person. Okay. So, it only governs the transfer of property between living person. Act mainly deals with the transfer of immovable property, but certain sections of this act are also common for movable as well as immovable transfer. Then Sales of Goods Act is specifically for the movable property, which came in 1930. So, I told you that this act is not exhaustive about, first of all, the nature of transfer, that means movable or immovable. That means, mainly it is for movable, immovable, and some part of the movable are codified under this act under chapter 2 and some portion later on. Then after, certain part of a main part of movable property transfer is governed through the Sales of Goods Act. Then Act has provided a parallel law to already existing law of testamentary and interstate transfer. So, this is all about the preamble of the Transfer of Property Act. This diagram is about the scheme of Transfer of Property Act 1882. Transfer of property can be divided into two parts. First is act of the parties, by act of the parties, and second is by operation of law. By act of the parties, that means between the living person, it is inter vivos transfer, and by operation of law, that means if there is a death of a person, then their heirs will get automatically. Okay, so in that way it may be. So inter vivos by act of the parties or testamentary succession. Then this inter vivos may be transferred into the transfer of property, whether immovable or immovable, that is chapter 2, section 5 to 37 and section 22 to 137. That is, this portion is applicable for both movable as well as immovable property transfer. Transfer of immovable property is specifically under chapter 2, chapter 3 to 8, okay, and mainly these immovable transfer has been categorized into 6 categories, that is sales, mortgage and charges, lease, exchange, gift and transfer of actionable claim. So, immovable property transfer mainly it has been categorized into 6 parts, but before that there are number of provisions which talks about transfer of movable and immovable property. That means it will be applicable to both kinds of property. So, this was all about the scheme of the act itself. Now, come to the interpretive clause. First of all, in interpretive clause, I am going to discuss the concept of immovable property, how immovable property has been defined. So, transfer of property act does not define immovable property in detail, but it says that it is a kind of exclusionary provision which excludes that what will not fall under immovable property. So, it says that immovable property does not include standing timber, growing crops or grass. So, meaning will be not clear in that way, that what is included under the immovable property. It says only that standing timber is not immovable property, growing crops is not immovable property and grass is not immovable property. So, in that way if you will see that it is not a comprehensive definition or it is not a exhaustive definition. So, for knowing the meaning of immovable property, certainly we will have to go to the other statutory provision, and for that purpose Registration Act is one of important act which defines immovable property in this way, that immovable property shall include land, building, hereditary allowances, right to ways, lights, ferries, fisheries or any other benefit to arise out of land and things attached to the earth, or permanently fastened to anything which is attached to the earth, but not standing timber, growing crops or grass. So, it has been again in this Registration Act because it came later on. It is 1908 legislation. So, it has included those 3 which has been mentioned under the TPA Act, Transfer of Property Act. But here it has been said that immovable property shall include land, building, hereditary allowances, ways, that means rights related to the properties, benefit which is going to arise from land or things, then anything attached to the earth permanently fastened. So, all these will fall under the category of immovable property. The next act is General Clauses Act. General Clauses Act section 3 clause 25 defines immovable properties as follows: immovable property shall include land, benefit to arise out of land and things attached to earth permanently fastened to anything attached to earth. So, this is a very important definition under General Clauses Act, because general clause importance of General Clauses Act is that if something is not defined in any act, then there should be the inferences from General Clauses Act, that what has been defined under the General Clause. So, this is General Clauses Act means it is a kind of the residuary act for definition that something is not defined in any act, then we used to take the help of General Clauses Act. So, General Clauses Act clearly mention that immovable property includes land first of all, then second important point is any benefit arising out of that land. So, all kinds of benefit will fall under this category, and third is things attached to the earth or permanently fastened to anything. So, all these I am going to discuss one by one. So, it is not also exhaustive definition, but anyway it has tried to give a more elaborative definition which has been developed in due course through judicial decisions. So, first of all come about the land. So, what is the meaning of land here? So, land includes following elements which is considered in its legal sense. What are those? So, first of all, what land means? Land means first the determinate portion of earth surface, that means any part of the earth. Then column of space above the surface, that means just above the any land, that means air is there. So, that space above the land is also the part of land. That means not only the land itself, but the air above the land is also the part of land. So, generally who owns the land, they will have right not only to use the land, but make the construction over that land for multi-story. That means up to that air, the person who will have right over that they will have claim. The same principle apply in international law also, that any state has a particular territory. So, every state will have what? Air space. That air space is the part of the right of the state itself. The same principle apply in the municipal law also, that every individual will have right over air in case of if they will have certain portion of land. Third point is the ground below the surface, the ground beneath the surface, that means below the surface also, that means the part of any kind of water, minerals, all these will be the part of that. So, that will come under the category of this immovable property. Then all objects either or under the surface of land, whether land in their natural state, they also come under the category of that. That means, if you are getting water from underground water, that is the part of the land, it will be treated as the land. If there is a minerals, that is the part of the land. Okay. So, whatever it is going to be found in the state of nature, that will be. Then all objects placed by human agency either on the land or this with the intention of permanent annexation, that will also fall under the category of land. That means, if any human being which has made any permanent structure, okay, on the surface of land with the intention of permanent accession, in that case also that will cover under the land. Now, second important issue is that is about the benefits arising out of land. This is the most important part, that not only the land what we have discussed, but any benefit which is going to accrue from the land right, that will be also a kind of immovable property. So, common man generally understand that immovable property means land, but if certain rights attached to that land is that, take the example of that right to cultivate. So, whether this right to cultivate itself, because it is right to cultivate is not a kind of thing which is visible in nature, okay, but this right exists, claim exists, So, whether this claim is movable or immovable. Okay. So, here it will be said that this right which is accrued due to the existence of that land or ownership of that land, then it will also fall under the category of immovable property. So, here example has been given that in case of if you are going to collect certain kinds of lakhs or leaves from your land, cultivation, right to cultivate, right to give any kind of lease of that, because that you are also a right to lease your property, and when you are leasing your property, that means you are accruing the benefit from it. So, that will also fall under category of immovable property. Right to collect the fees, debt secured by mortgage of immovable property, debt secured by the mortgage, not mortgage itself, mortgage you are doing the of the immovable property. Here it is about the debt secured by mortgaging, that debt secured by the mortgaging is also immovable property. So, this may be tangible and intangible, because whatever the right is there, that is intangible in nature, which is not visible. So, benefit arising out of the land, it is in intangible form. Okay. So, sometime it has happened, then any right which exercise over the land, it has been said that makes profit or gain is intangible immovable property. It is very important. So, you should not be confused intangible immovable property. Why it is I am underlining? General understanding is that immovable will be always visible in nature. This is not the case. Immovable may be visible, that means it may be corporeal or it may be incorporeal. So, mainly the right which is coming out of the property, it is mainly it is incorporeal, it is not visible. That means, you have a right to put your flats on rent. Flats is a kind of immovable property, and right to put it on rent, it is a kind of benefit accruing from that flat. In that way, this right to put on rent itself is a kind of immovable property. We cannot say that it is immovable property. So, it will fall under intangible immovable property. Then it right to profit out of immovable property, which I have already explained. So, these are certain examples which you are seeing here, that is a right to enter upon land or to carry away fish from a pond is a immovable right, a right to graze over land of another is a profit, a right to enter upon land and remove trees, a contract to fell, cut and remove bamboos from the forest, all these things are immovable property. Okay. Then third essential is attached to the earth. Attached to the earth is a very important part of the immovable property. That means, first we have covered land, second we have covered benefit accruing from the land. Now, it is attached, it is not about the natural one. When we are using the word attached, that means not it is in natural form, because natural form of attachment is already covered under the part of land itself. Okay. So, here it is man-made attachment. So, what is the nature of man-made attachment which will fall under the category of land? So, first section 3 of the Transfer of Property Act defines attached to the earth means, first it is rooted in the earth. Okay. In case as in case of trees and shrubs, then it talks about the embedded in the earth, rooted in the earth, embedded in the earth, in case of wall or building, like that. And third is attached to what is so embedded for permanent beneficial enjoyment as to which it is attached. So, these three things are very important. We talks about the attached to the earth. This is coming from the definition of the immovable property itself. Okay. So, things, first of all we come to the things rooted in the earth. Things rooted in the earth means what? That here it has been said that all those things, trees mainly, which is rooted, these are trees not immovable property, they are not immovable property. Okay. In case of trees and shrubs, all the trees are not immovable property. Why all the trees are not immovable property? Because there are the nature of tree which can be severed from the earth, which can be cut and can be made into the movable, property. So, those trees which are used as a standing timber, which are cut for the use of timber, fall under the movable property. So, we can divide here trees into two parts. Some trees, that means some species under the botanical kingdom, that plant kingdom may fall under movable and may fall under immovable. Immovable are those which are attached, and generally it used to attach in the state of nature itself. So, grass and shrubs are treated like under the nature itself. But in case of timber plant, it may be movable, it may be immovable. It completely depends upon how it is going to be used. Timber plant may be in the forest. Okay. So, when it is in the forest, not for the purpose of timber, just it is a plant grown in the forest and remaining in the forest and in protected areas. So, in that way it will be a kind of immovable property. But once it has been grown for the purpose of cutting, or the forest has been converted into or sold for the purpose of cutting or taking wood from it, it will be converted into a kind of this movable property. Same way it happen with the fruit plants. If fruit plants is found in a state of nature, then it will be a kind of things which will be immovable property. But once you are growing this fruit plant for the purpose of cutting and all and using for sale, then that fruit plant will fall under the category of movable property. Okay. Next important point is embedded in earth. The test of immovability is whether or not the things rest by its own weight on earth. Embedded in earth means what? That means any things must be embedded in earth by its own weight, and whether it can or cannot be changed place and be removed from one place to another. What is the meaning of embedded? That means first criteria is that weight should be like that it is embedded in the earth by its weight itself, and second criteria is it cannot be replaced. Then only it will be treated as embedded in earth, that means it is immovable. What is the meaning of embedded in earth here is, the main feature of this terminology is that it cannot be moved from this place to that place. So, whether a thing is embedded in earth or not can be tested on the two ground. First is degree and mode of annexation, I have underlined here already, and the object of annexation. Okay. So, how it can be? That degree and mode of annexation, to what extent it is annexed. That means, if there is a building, multi-story building, and there is it is completely fixed under the earth up to the 100 feet to, or 60-70 feet in multi-story. So, generally it is treated as embedded in earth, it is not for shifting purpose, it is not going to replace in future. Then object of the this is object of annexation. Object of annexation means that the object itself is annexed to the earth in that way that it cannot be moved or it cannot be replaced. The best example of this is the well. The well is a man-made construction, but it is a man-made construction in that way that you cannot shift a well from this place to that place. So, it is the object of annexation. So, in case of Holland versus Hodgson, this UK court said, Lord Justice Blackburn observed that the true rule is that articles that are not otherwise attached to the land than by their own weight are not to be considered a part of the land, unless it is shown that they were intended to be part of land. That means, the primary criteria is that first of all weight should be like that it is considered as the this weight, through weight itself it is embedded, or if it is weight is not a criteria, then the purpose is the criteria, that it has been made for that purpose, that it will be treated as permanently fixed. Then attached to what is so embedded. That is also, that is the things which is embedded, in that it is attached, and more confusion used to happens in these words only, that attached to the embedded things. What is the meaning of this? Where a thing is attached to something embedded in the earth for the permanent, in the case of permanent structure, then within that permanent structure you are going to fix certain things, just like windows, ceiling fan, doors and all. These are not for the purpose of replacement. Okay. So, the things which has been used is a permanent, on a permanent basis, that it is not going to be replaced. You can say that that door may be replaced after 10 years, 15 years and all, but it may be said that you can change your doors, you can change your ceiling fan, but the purpose was not for the change, only is that once it has been that means defective, then you are going to change it. So, the intention is also important for that purpose. So, it has been used in that case, last case, that the purpose is also important if it is not embedded. So, if you are attaching something on the basis of permanent basis, then it is also becomes the part of this immovable property. So, standing okay. So, it has been said the ceiling fan and all, but at the same time electric appliances just like geyser. So, geyser, press, which fridge, these are also you are going to use, and you can say that it is attached to this, we are taking electricity from that for the specific purpose, but they are not the part of the building, they are not the part of the enjoyment of the building. So, for that purpose it has been said that they have been kept as movable, not immovable. And next you will see that the things I have already discussed about these three, that is standing timber, that is about the growing crops, and grass, they fall under the category of movable one. Movable one, that means they are this standing timber, growing crops and grass, they are immovable in nature, because their nature is that they are attached, embedded, purpose is very clear that they are not going to be derooted. If they are going to be derooted for the certain purpose, then it will become movable property. Okay. Now, it was about the movable property. Then there are certain rights which we have already discussed, that certain things going to be accrued, certain rights which is going to be accrued from the this immovable property is also fall under the category of immovable property, and through various judicial decisions it has been decided, and generally it is used to come in examination, that whether these kind of properties are movable or immovable. Okay. So, if right is going to be accrued from immovable property, that will also fall under this immovable category. So, right of ferry, right of way, right to collect rent of an immovable property, right to catch and carry away fish, hereditary offices, offices of a hereditary priest of a temple, all has been declared as immovable property. Why? The best example is with the fish. Fish, now fish is movable, fish is a living thing, but when it remains in the pond, at that time it is called immovable property. It is not outside of the pond, because it is in a state of nature and it is the part of the land. Okay. So, fish in pond is immovable property. Once you will take it out from the pond for the purpose of selling it, it will converted into movable property. Okay. Third category is that right to use that pond for fishing, whether it is movable or immovable. This right is coming for the purpose of fishing, and it is related to pond, which is immovable property. So, this right is accruing from the pond itself, in that way it is immovable property. Okay. So, right coming from that pond, right coming from that building, okay, right coming from temple, because priest has a right about the offering of the offering from the temples. Okay. So, this temple itself is a kind of immovable property, and the right has been accrued from the temple, that is the right of the priest to take the all offering of the gods. So, in that way it is a kind of immovable property. Then right to collect dues from holding a fair on piece of land, that means tax for fair. Then right to collect lac from trees, right of redemption of mortgage property, okay. Reversion of reversion in property leased, okay. Factory, a factory itself, interest of a mortgage in immovable property. Interest of a mortgage in immovable property is also immovable property. Now come to the movable property, okay. What is this? Now, if you will go through the definition of Transfer of Property Act, okay, then you will see that there is no definition has been given under the interpretive clause. So, generally we used to take the help of General Clauses Act because it is not defined. So, we will go to the General Clauses Act. General Clauses Act says that movable property means property of every description except immovable property. So, all description except immovable property what we have discussed here. Okay. So, all those things which are falling under all the things which are not falling under immovable property will fall under the movable property. So, the following things has been held not immovable property: a royalty coming from any thing, that is any book, any movie and all. So, this royalty has not been taken as immovable property. Okay. You are taking royalty from your books, movie, music, mainly the intellectual property related things. Okay. So, these royalties are falling under the category of movable property. Next is decree of the sale of immovable property. Decree of sale for immovable property is not immovable property. So, it is movable one. The next is decree of area of rent. This a decree for area of rents. Rent itself is immovable property. Rent itself, because rent is coming from immovable one. Suppose and rent it is coming from the movable one. Okay. So, rent if it is coming from the movable property, then it will be movable property. That is, you have rented your car to any company, just like Ola. So, once you have rented your car to the Ola company and you are taking rent from it, then it will be movable property, this rent. But if rented your house which is immovable, then that rent will be immovable. So, all rent will not fall under immovable property. The nature of property will determine that which rent is going to fall under movable property or immovable property. So, here it has been said that in the case of decree of the court about the area of rent, so this decree is coming through the judgment of the court. Okay. So, in that way this right has been created by the court about the area of the rent. So, this decree has given this rent. So, it this decree has given that right. In that way it will not fall under the category of immovable property. So, it will be a movable property. Then right of worship. What are the movable property? So, right of worship is a kind of movable property. Okay. Machinery which is not permanently attached to earth. If it is not permanently attached, that means it can be moved from here and there, then it will be the part of this machine. Now, here you should be make a distinction that machine may be related to the any kind of work and machine related to the use of the building or immovable property. When we are using a machine, just like I have given the example of fan, okay, or a kind of this AC. So, this is related to the rights of the enjoyment of immovable property. So, right of the enjoyment of immovable property it is called, generally it is coming in the form of use of that property itself. So, it may fall under the category of immovable property. But when the machine as a fixture we are going to use not on the permanent way, then this machine may be called as movable property. Okay. So, machine, if I am going to use this machine for the purpose, any machine or any motor for the purpose of 1 or 2 months in my house or in my building, then after it will be not in use, in that case it will be a movable property. Just like we used to take the help of generator, okay, generator for 1 or 2 months. Okay, we used to take the help of other kinds of motor for the different kinds of work. So, these are known things that it is going to be removed after certain period of time. So, the intention is very clear that it is not going to continue, in that way it will be a immovable movable property. Then actionable claim. Okay. Then actionable claim means, actionable claim means what? First of all, you have to understand, actionable claim means a claim to any date other than a date secured by mortgage of immovable property or by hypothecation or pledge of movable property or any beneficial interest in movable property not in possession, either actual or constructive, of the claimant, which the civil court recognize as affording grounds for relief, whether such date or beneficial interest be existence, accruing, conditional or contingent. Okay. So, first of all it says other than the date secured by mortgage. So, first of all it is saying that the right which is coming from the movable or immovable property, it is not going to fall under that actionable claim, because actionable claim we are discussing in the sense that as an independent part. We are not going to discuss that the right which is accruing from movable or immovable, that has been already discussed. This is a claim, this is also interest, legally protected interest, a kind of right of individual against certain things. Okay. So, a claim which is legally entitled claim against certain things, okay, that may fall under actionable claim, and most of the actionable claim has been determined by the judicial precedent. Just like here example I have given, the sale of lottery tickets amount to transfer is an actionable claim. Sale of lottery tickets amount to transfer of an actionable claim, that I won the lottery. Okay. So, I purchased first of all the lottery tickets, then I won it, and after getting it, I won that particular lottery, then I have a certain claim over that. In same way, if in case of tort, okay, so I had certain rights, which rights has been violated. So, once it rights has been violated, then I have claim against the defendant. Okay. So, once I am going to claim certain thing in case of negligence or recklessness, then that claim has created right against that defendant. So, this kinds of right will also fall under the actionable claim, but you cannot say that this is a movable property or immovable property. This is not movable property or immovable property, it is a right independent from right accruing from movable property or immovable property. So, it has been dealt by the judicial precedent, right to recover insurance money. Right to recover insurance means, that means I have paid premium up to the number of years, and then I need that money after the term, completion of term, or in case of any exigency. So, in that case the claim has been created by depositing those premiums on time. Okay. Same in the case of death, if you are a regular premium submitter, that means you are depositing your premium on the regular basis, and that was the life insurance, and something happened to the person depositor, then his ward or wife will have a right against that insurance. It cannot be curtailed by the insurer company. Okay. But suppose the person was defaulter, he has not deposited premium on time, in that case it can be said that he has not fulfilled the requirement. So, claim is not settled. So, claim will be not settled in that case. In same way, right of a partner to sue for accounts. This is about the partnership. That means, in the case of partnership firm, there is a all partner will have equal rights, or according to the agreement they may have certain shares in that, okay, in profit. So, in partnership what happens, that every partner will have equal rights against the other partner. If one partner is taking more benefit or keeping the account, in that case another partner will have right over that account. So, this is also a kind of actionable claim. That means, in simple word you can understand a claim on which you can bring an action. Okay. That means, for claim for that kind of the interest in the form of claim, for which you may go to the court of law and say that, okay, these are the my claims and must be given to me. In that way it is a kind of actionable claim. So, claim for arrears of rent and the right to credit the provident fund have been held to be actionable claim. So, these are also actionable claim. Okay. So, it is all about this interpretive clause. So, once I come to this overall, if I am going to explain about the basic objective of Transfer of Property Act, then we find that this act itself, just I am going to give you a summary of it. So, we find that this kind of act has been specifically created after the Contract Act, because there was a certain gap in the Contract Act itself, where it was not sufficient, because if you go through the original Contract Act, it includes the sales of goods also, okay, which has been deleted now. So, that was covering the movable property transaction, but the immovable property transaction was left in that. Okay. So, there was requirement at that time, because India was moving in the form for industrialization. The Britishers were doing for their own benefit, but certainly it was a kind of transaction was increasing in India. So, there was a requirement of taking of the immovable property from individual to develop it. So, in that way there was a requirement of proper legislation. So, for that purpose they came with this one, this Transfer of Property Act. So, if you will go through the all this, then this movable or immovable property has been categorized in the definition part itself, that what will be amounted as movable, what will be amounted as immovable, through the help of General Clauses Act as okay. And then we come to see that in case of rights accrues from the immovable property, we will see all kinds of these rights, whether it is the mortgage, whether it is a lease, whether it is a kind of gift. All these things we will see later on, that they have how they have developed on immovable property, and this act recognize those rights, and there is a proper way of transfer it, because how you are giving gift, what are the essential of gift, what are the essential of lease, when lease will be completed, what are the rights of the lessee. In same way, when you are putting certain things on the for the mortgage, then what will be the rights of mortgagee, what will be the rights of mortgager, what are the duties of mortgage and mortgagee. All these things has been deliberate through deliberation, it has been came into this form. So, overall this Transfer of Property Act is talk about certain fundamental parts which applicable to the movable as well as immovable, and mainly it governs the immovable property rights, okay, how it can be transferred and how it will be done in a proper way. So, there should be less dispute, there should be less this conflict, because the main you can see that how it has been become important, and chronology of the legislation at that time. First of all came this Indian Penal Code, then it came to the contract, then this was the TPA, Transfer of Property Act. So, first there was the crime, there is a requirement of the control of the crime, then after there was the requirement of the free contractual obligation creation, then after there was a requirement of this Transfer of Property Act. So, chronology of this enactment of different statutes during the British period will give you the importance of the interest of the British East India Company, and according to their priority they have legislated different law and legislation in India. TPA is a very important legislation, and it is one of the main law related to the law of property. It is still govern, it is still govern in this. Okay. And this law is mainly these days, in addition to other minor laws, play a very important role in the real estate business these days, as well as general transaction of the general transaction related to the immovable property, including some part of the movable property. So, in the next lecture, I will discuss the meaning of transfer of property itself. Okay. And then we will start the proper section wise detail different kinds of rights which has been provided under Transfer of Property Act to the individual for the this transfer of property. So, it is all about from my side in the introductory lecture. I wish you all the best. Thank you.